Arrested? You've been arrested? I'd like to review with you the three ways in which law enforcement officers derive the authority to actually place someone under arrest. First, and as we've discussed before, in order to be arrested for a crime, the police or court must find probable cause that you've committed one. Probable cause is a fairly low standard, but it's not nothing. It is a constitutional standard that the state must meet prior to arresting anyone. It's more likely than not that you've committed a crime. Once probable cause exists, there's three ways in which police find the authority to actually put you under arrest. The first is if a crime occurs in front of the police officer. When police officers actually witness a crime, they have an opportunity to arrest you right then and there without any further process. So the common example of that is a DUI. You're found driving erratically, police pull you over, there's an allegation of odor of alcohol, you fail field tests, and police through that process establish probable cause and have witnessed the offense in front of them and then can immediately arrest you. However, when a matter is subject to an investigation and police didn't witness it, there's two other paths law enforcement must take in order to secure authority to arrest you. The first is through an arrest warrant, which is similar to a search warrant. It's a process whereby police, in a sworn written affidavit, summarize the investigative facts to support their view probable cause exists that you have committed a crime. They then submit that warrant application to a court, and a neutral and detached magistrate then decides whether or not police are right, whether or not there is probable cause, and if a court agrees, then an arrest warrant issues and police are authorized to then arrest you. Last but not least is a direct indictment by using the grand jury process. That's when there's a long-term investigation and police and prosecutors together go to the grand jury, which is a group of citizens from each county in New Hampshire that sit in secret at a time we're not aware of, but usually 2 or 3 days a month, in order to consider police and prosecutors and the presentations they make with regard to the cases then under investigation. And in that instance, a quorum of the grand jury will also agree probable cause exists, you've committed a crime, and then in turn issue a true bill, which is they send out the indictment, and in that case, the indictment as well as scheduling notice for a first appearance is typically sent to the defendant or the wrongdoer. So those are the three ways in which police in New Hampshire derive the authority to arrest you for an alleged crime. And if you have been accused of a crime, feel free to give us a call. My name is Jim Rosenberg. I'm a lawyer and a partner at the law firm of Shaheen and Gordon. We have offices throughout the state of New Hampshire and in Maine as well.